I would like to have a comparison that if as a student of human rights and a student of law, we compare the articles of the Universal Declaration of Human Rights with the articles of the Constitution of Pakistan, we will see the same formulation of rights as we saw in the Universal Declaration of Human Rights, or the two covenants which is called the International Covenant on Civil and Political Rights and International Covenant on Economic and Social Cultural Rights. Like we had seen that the due process of law in Article 4, and we saw that the constitutional provision Article 8, that no law or practices which is in conflict with the fundamental rights will prevail. So that means we had seen that these fundamental rights theory was incorporated into the Article 8, and then again we saw that mostly all the constitutions of the world revolve around four things. One is right to physical integrity, that one should not be tortured, subjected to inhuman treatment or punishment, or arbitrarily arrested or detained, so right to personal security. The second stream is about the public freedoms, like the right to religion, freedom of expression, freedom of opinion, and freedom of assembly, and freedom of movement. So the second stream is of the public freedoms. The third one is right to privacy, both in private and public sphere. And the fourth one is the safeguards to the right to property. So we saw these four categories incorporated into the Constitution of Pakistan in Article 8 and Article 9, that every person has a right to life, liberty and security of a person. We will see that this is the Article 3 of the Universal Declaration of Human Rights, that every person has a right to liberty, security. And again, Article 10, we saw that because in Pakistani Constitution, no one shall be arrested arbitrarily or detained, and so we saw that article again in Universal Declaration of Human Rights. Article 11, that the slavery and bonded labor or forced labor is prohibited, and human trafficking in Article 11 we saw in Article 7 there. So Article 12, we saw that prohibition from the retrogressive punishment. Article 13, 14, self-incrimination, and 15 from right to movement, 16 association, 17 association, 18 freedom of trade, 19 freedom of speech, 20 right to religion, and 21 these are the safeguards about the children of belonging to minorities, and 21, 22, 23 and 24 are subject regarding the right to have property and protection of property. And we saw that in Article 25, that is right to equality, equal standing clause, and we saw then again 26 and 27, right not to be subjected to discrimination in services, and Article 28 is about right to preserve of culture. So what I'm trying to say, that if we analyze the articles of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, Cultural Rights, you will see the same language, the same scheme of wording incorporated into the Constitution of Pakistan. So it is on this empirical study that we must inculcate those who are saying that the international human rights law is alien to our Constitution. They must read that what is the Universal of Human Rights, Declaration of Human Rights, what is the International Covenant on Civil and Political Rights, how it has been incorporated into our Constitution of Pakistan, Having said that, I say that in today's world, when we talk about human rights, basically human rights gives tools. Basically, human rights empowers the weak to get the legal redress, and human rights criticizes even those laws which are unjust. So the constitution of Pakistan, and even we see that a lot of judgments of the superior courts has articulated the international human rights provisions. But it must be mentioned that Pakistan is following the common law system. We are a country following the dualism. Dualism means that international law and domestic law, or we call it a municipal, however you call it, domestic law, national law, or a municipal law, or internal law. Dualism means international law and municipal law are two separate regimes. You cannot treat them as a one. So in order to get the international law or human rights law incorporated in domestic law, we need to make enabling legislation or incorporate the domestic international law into domestic law. Then the courts, then the executive authorities will be able to translate those international provisions of human rights into domestic education.